Coming to you straight from the Rio Grande and beyond. Broadcasting to the four corners of the globe. So grab your seat, your coffee, or your sundowner.
Okay, everybody, here we go.
On point, as always. This is Gloves Off. Gloves Off.
We're back at you with Gloves Off. I'm Paul Buitron, and I'm here with Dr. O'Connor. We're touching base on parent alienation and where does it start? Doctor, how have you been?
I'm good, thank you. Thank you. It's a pleasure, honor to be on your show.
It's also
thank you.
It's a pleasure to hear you because you're a sage in this field, and a lot of people need to pay attention to you. And I know that there's a lot of parents out there that are suffering over alienation, parental alienation. And it's always been the question of many. And the question that I have would be, where does parent alienation start? Does it start in the courts? Is that where it manifests itself? What would you say?
I would say that it actually starts with the individual parent, and it will progress into the courts, unfortunately, which mistakenly the courts will reinforce it or enable it. Even in marriages or in cohabitating situations, depending on the parents involved that are raising the children, there are parents that function under the premise of always having a quote unquote one-upmanship, always attempting to make themselves look best, on top, in control, the boss. And that may be their way. They do that in front of the public arena outside of the home, but they also do that in front of the kids. And then when there is a separation from cohabitation or a divorce, the situation, just plainly said, can just get a lot worse. Now, I think that in Texas, the standard possession order, in and by itself, even if you weren't having a parent that was competing for the attention of the child or the children, you look at it in cohabitating and married situations, parents have frequent contact with their children, children have frequent contact with their parents. It may or may not, in every cohabitation or married situation, always be exactly equal, depending upon the job structure, the structure of the family, the activities. But it's frequent. And when there is a non-cohabitation situation or divorce, and there's a SAPR case, as they're commonly called, you're pulling away one of those parents, or you're pulling away from the child one of those parents most commonly. And in our society and in Texas, we're pulling away the fathers most commonly. And there's actually been some studies, or I should say surveys, by others looking at the data from the Attorney General's office, county by county by county, and separating the percentage of non-custodial parents and custodial parents, and separating it by gender. But from a child perspective, which is what is really paramount in this situation, from the child's perspective, we're taking away from the child one of the parents from an almost equalized association to most commonly the father, and it can be also the mother less commonly, down to 20% to 30% of their daily time, their daily existence. So you're going from almost half and half in a married cohabitation situation to 20 to 30% of that. You're separating from the child a parent.
Absolutely. And, many times, as many parents go through it, and they go through the change and they continue going through the custody battles, you see more and more the magistrates actually aiding the separation while they claim it's for the benefit of the child. They're actually aiding in the parental alienation. I don't know it's because lack of knowledge, or they don't want to acknowledge it, or what do you think is actually happening with that? In your
I think to
view?
answer the question directly is that it's not that they are acting improperly. I think a better view of it is that what they've been taught, either by their own personal upbringing, their own personal environments, or by professional organizations that they've been exposed to up to this time, what they've been taught has been incorrect. And there's been a failure or not knowingness of really decades of research with the child developmental psychologist, and more, I would say, with the child psychiatrist. So, and I think another factor is that there's an easy way to go about things, and then there can be the right way
Sure.
to go about things. And sometimes the easy is the right way, but most times in these situations, the correct intervention is not the easy intervention. I think that, the child custody issue laws are based upon property laws. And many states, including Texas, still use those terms, possession, to infer the child is property. And that lends a focus and maintains the focus on the litigants. The property is the property of the litigants, the property of the parents. And I think that there is still an undue focus on the wants, desires, or feelings of the parents. Although I would say there is more and more focus in awareness on really pulling away from that perspective and looking at what are the needs of the child. I think that the courts unknowingly contribute to the alienation process.
So coming back down to that, I know that the courts unknowingly contribute to that. Is there any way we can teach or educate the courts that is being happening? Or have they tried to teach the magistrates that this is going on? What is their perception towards it? And of what you've witnessed?
Well, again, I think everybody, or for the most part, a lot of people that are involved in the child care reform in Texas and in many states, much of their involvement first stems from their own anecdotal experience, and then they're of the mindset where they take that anecdotal experience and they turn it into more of a global contribution to their society. So they get involved in these movements. I think that if we look at education to the judges, I think that's probably going to be the most important thing. You look at the Association of Family and Conciliation Courts, which does a lot of education for the judges, but there's so much influence, I believe, from those that want to keep the system the same, those that continue to focus just on the litigants and not for what is considered the best outcome of the child. And I use the words best outcome of the child because I think that the phrase best interest of the child is too ambiguous. It's really never been defined. And the best outcomes of the children have been more and more defined over the decades among the science and the scientists. I think that if we assume that all adults are healthy, adaptive human beings, and that post-divorce and post-cohabitation, when they're separating, they can really go past their emotional states, go past whatever phase they are in thoughts and emotions about their ex, so to speak, and they can focus on the child, what's best for the child, then, with the standard possession order as it states in the family code, it's the minimum, not maximum, but minimum time that will promote the best, quote, interest of the child. Now, if you have healthy functioning adults, I think that could possibly work out, because the healthy functioning adults will go past these restrictions and come to mutual agreements that they realize are best for the child. They'll go past just looking at what's best for them as a person, or what they're best for their feelings, to soothe their feelings, and they'll look more at what's best for the child, i.e., I may not like this person, I may not agree with this person, but I know what's best for the child. I know what's best for our son and our daughter is for both parents to be supportive at these activities, or to have as much exposure to both of us as possible. The problem with the standard possession order is not every parent is like that. In our society, not every person is like that. And so when you combine someone, or a parent that's not functioning, looking out for what's the best outcome, not willing to take a look at the factors that promote best outcomes, not willing to listen to others, listen to the research about what's the best outcomes, and continually focus on themselves, and you put them in this paradigm of the standard possession order, my God, that's an ideal situation to start lopsiding the relationship of the child or children toward one parent and eliminating the other parent. And essentially, the elimination is the process of alienation. And alienation can occur physically, and we know, what I would call the most outrageous, unfathomable, difficult to understand situations is when a parent is literally withholding the child from seeing the other parent, absence any issues, except for issues in which is direct harm. But when there's issues of not direct harm to the child, emotionally, psychologically, physically, and a parent is literally withholding the relationship, the physical presence of the other parent and the child, that's the most outrageous behavior, and the most obvious form of alienation. Unfortunately, I think the judiciary only sees that as alienation, and they miss the issues of the emotional, psychological brainwashing occurs of the child or children, in which one parent turns the child or children against the other parent. And they do that by very overt, bashing, verbally bashing methods, or even more subvert, emotionally manipulative methods. And I think the judiciary they're not educated enough or receiving enough education to identify these methods that are very damaging, and more recognized not only as damaging, but more and more recognized as an existence phenomena, similar to occult brainwashing, which is very damaging. And I think that this issue is beyond the research stage now. It's a founded peer, what we would call a scientific peer accepted phenomenon, a scientific peer accepted issue that does occur with kids. And unlike if you're in a criminal court, which is something I've been considering, the contrast, when you're in a criminal court and you deal with criminal judges, which thank God I have not, but in looking at the literature and looking at case law, criminal judges, I think, are, in my opinion, more astute at picking up the issues of deception among witnesses, litigants. And I'm wondering if there is a difference in training, a difference in knowledge about picking up the issues of deception in civil courts, in these family courts. It is well broadcasted, as you know. We've heard stories from numerous parents being in a courtroom, in a family court, so to speak, and this X or that X, they say X, Y, and Z to the judge, and their statements are totally contradictory to other eyewitnesses or documentation that's submitted. But yet the family court judges, don't do anything about it. You know, you rarely hear about perjury charges
Sure.
or the litigants being called, so to speak, on the carpet. Versus in a criminal court, it would be less welcome and less tolerated, and there would be more immediate and severe consequences. And so, who really suffers if we pull it out of the realm of looking at the litigants, the moms or the dads, and look at, you know, how does this affect children, and drive that education toward that perception, and somehow incentivize that decisions made must be decisions primarily for the best outcomes of children.
Sure.
I think that there can be more and more of a change. Again,
Absolutely.
I think it would be easier to look at this situation as an all or none. You know, there are bad judges, good judges. I think that that's very rare that you're going to find bad judges. It's very rare that you're going to find good judges. They're all kind of somewhere in that gray area. And lending some understanding that they're also dealing with their performance evaluations if they're associate judges, understanding that in some form or fashion they're state and county employees, understanding that, you know, their dockets are full, and versus their objective civil cases, family court cases are much more emotional, and many of the judges don't like dealing with them, because there's also liabilities involved, and their dockets are full. They want to clear their dockets, unfortunately. And there's also misinterpretations of the law. And I think misinterpretations of the laws is now becoming more and more in awareness of citizens or parents involved in this whole process.
Absolutely. I guess as you said earlier today, I'm going to go back, you said that the standard visitation is kind of like the seed to parent alienation through the courts. Would you think that 50-50 parenting, co-parenting, if it was given as a first outcome, what do you think about that? Would that lessen the alienation?
It's been shown in much of the literature that it's an appropriate intervention to mitigate ongoing alienating techniques, prevent alienation of the child from the parent. And many researchers who promote early overnights with even infants to ongoing maximizing parenting between parents, with the exception if there's proven harm to a child, of course.
Sure.
It is greatly beneficial to children. It's greatly beneficial to the outcomes. There's across the world, there is not a researcher, well, there are exceptions, but across the world, there's a consensus that maximizing parenting time, shared parenting, is much more beneficial to children than minimizing one parent versus another. There's two things in looking at the issue of parental alienation and shared parenting. You can have a parent that attempts the techniques to alienate the child. It doesn't mean the child's going to respond to those techniques. Early on, if the techniques start early on, children are going through many different developmental phases. One of the phases, they believe fiction is fact. They can't tell the difference between fact and fiction. In that stage, they're very easy to manipulate. They sooner or later get to a stage where they can then tell what's make-believe and what's not make-believe. And when they're continually seeing a difference between what one parent is telling them and what they experience with the other parent, and vice versa, they begin to see the differences. They begin to understand that what they're hearing is make-believe, what they're seeing is actually the real thing. So you can have a parent that's attempting the techniques and you have a percentage of children that will respond. When the children respond, that then is called the syndrome. The child is responding to all the alienating techniques. They're now becoming sided with the alienating parent toward what we call the target parent. And then there are children that don't respond. They just have a resilience. Unfortunately, and I want to be very reserved when I say this, because I think I need to look into the exact statistics, but unfortunately, it appears that the percentage that don't respond is smaller than those that do. And now you have another subset of kids that may initially respond, and then at some point during their childhood, adolescence, or teenage years, they get it, so to speak, in which they have what's called the boomerang effect. When they realize how there's been an attempt to manipulate them, that what they're being told or how they're being emotionally manipulated is not true, that the so-called target parent isn't the bad person, and it's okay to have a relationship. And when they boomerang, they basically start, unfortunately, favoring the target parent. And then they start alienating the original alienator. But that's still continually damaging. So early on, when you start equalizing the exposure of the child to both parents, the child sees more and more real-time exposure to both parents, not just a majority of time to a potential alienating parent. And so there's less concrete time for that negative influence. There becomes more concrete time for the real exposure at an early life to what they're really experiencing, the nurturing, the safety, the accessibility, the love, the promotion of their well-being. And as that goes on, the child becomes less vulnerable, more resilient to the potential alienating techniques. And I think it really is a disservice to children to either not be aware or not believe or be so overcome by bias from one force or another to believe that this cannot occur. I mean, we take a group of adults and, I think a famous case is Jim Jones. Adults can be easily brainwashed. A personality that's able to perceive one's weaknesses with skill can easily pick up on others' weaknesses, exploit them, influence them. And we've had several examples in our society of cult brainwashing.
Sure.
Adults. Now, just imagine the same type of thing occurring with a child who's much more vulnerable. This is extremely damaging. So the way to mitigate the potential psychological, emotional damage to a child is to maximize parenting as soon as possible. And this will really, it's like a vaccine, really. And more what you're seeing among different states is they're beginning to catch hold of this and do this. Did that answer your question?
Yes. No, it did. And actually, what you're actually educating us, and hopefully we can get some lawyers to hear this, some other parents to hear this. Hopefully we can get to the ears.
As a connection to this, I was thrown a question about why was it so important to see parents on a frequent basis. Another thing to consider is that kids, our time frame as an adult is much different than at different developmental stages for kids.
Sure.
A day for us as an adult, is depending on how old you are, a minuscule amount of time. For a child who's less than a year, that's a large amount of perceived time. A week time for a child in elementary school, early elementary, pre-K school, is a long time compared to the perception of an adult. So when you have these times where kids are going, not seeing the non-custodial parent for several days to a week, what they're actually going through, and the parent less so. But imagine, I think, to offer perspective as a non-custodial parent and non-custodial parents, whatever their profession is, what they go through when they don't see their own child but for telephone calls for a week.
Sure.
A week's time in a child's perspective is a far greater time. And the child basically goes through what I would describe many abandonment periods, and they suffer. And so sooner or later, if this is not mitigated, what happens in the context of making it worse with an alienating parent, these kids go through these, they see the non-custodial parent, they don't see the non-custodial parent, they go through this kind of abandonment grief, this sadness type period. They see them, they don't see them, and then when you have the holiday times of Thanksgiving and Christmas, where the child may not see the non-custodial parent for 10 days to 2 weeks, and then the summer times a similar thing can happen. Sooner or later, the child suffers so much they get tired of it, and in the face of having an alienator, as they're called, that's constantly manipulating them emotionally and psychologically, they just give in and they begin to align with the alienating parent.
Absolutely.
Or absent that, sooner or later they start to distance themselves and want to stay more and more because it's just too emotionally wearing for the child. And so maximizing time in frequency helps reduce and eliminate, although I hesitate to say eliminate, because it's hard to say when things are completely all or none. But maximizing time helps to eliminate and prevent not only issues of the abandonment emotions that occur in children, but it really helps mitigate and prevent alienating effects in the presence of an alienating parent.
Absolutely. And in other words, some parents know this. Some parents that fight for their children and go after their children will end up coming across the words parental alienation. And some out of those parents, some of them are going to start paying attention to it. And some parents will do their research, number one. But lawyers understand it. They understand that it exists. In Texas, parental alienation is really not used as much as in other states. But how can we get the judges to have more understanding of parental alienation? Is there any way we can mandate, not mandate, but make sure that they have a course of it once a year, especially those judges?
I think an avenue to consider would be that as a state and county employee, we would probably have to start with the legislation and the legislators, that if there's interventions that are going to affect children's emotional, psychological, and physical well-being, and anybody associated with carrying out those interventions that's working for the state or county must have mandatory education.
Sure.
Or credit hours in developmental psychology of kids and of parent-child and parent-parent dynamics. I think another potential intervention would be making it mandatory that each county has psychological or psychiatric advisors that can review cases or can do general education for the judges on a monthly basis or on a bi-monthly basis. And I've not heard of anything existing like that at all. Even
maybe it should be a push. Maybe it should be a push. Doctor, maybe it should be a push towards that.
I think
that if they were to understand that this exists, the syndromes of parental alienation exist and how complicated it is, I think they'll put it to their mind instead of some parent going up to court and say, it's parental alienation. They kind of look at you like, what are you trying to throw at? If they don't understand.
Well, you're right. And I think that it's a travesty. And Richard Warshak mentions this in his peer review article back in 2017. in which, a scenario in which the issue of parental alienation comes about, and judges can mistakenly think that's just some ploy by a non-custodial parent to gain leverage in a court hearing to get custody of the kids, without any investigation of the overall facts. And it really does a disservice.
Right.
If a parent is going to bring about the terms of parental alienation, let's say hypothetically the parent is doing that as a ploy, that still needs a good investigation of all the facts. Because a parent that would use that as a ploy in and of themselves would be an alienator. But in the event that it's a valid accusation, all the facts still need to be paid closely attention to. And the standard that is recommended is you start getting third-party evaluators involved who can more objectively look at both parents, look at the dynamics between the child and the parent, the dynamics between the parents, to find out and answer some of these questions. Unfortunately, not everybody, one, economically can afford to do that. And two, even if you can economically afford to do that, you're still depending upon the bias of the judiciary that's involved at the time. Again, I think that there is an underlying incentive as county and state employees, an underlying incentive in the Texas Family Code that must be overcome gradually. Going back to the term of maximizing or shared parenting, when you're starting from a rebuttable presumption of equalizing parenting time, what you're also surpassing is playing up, for the lack of better words, playing up or having to make decisions based upon one parent or another's feelings, or make decisions based upon the parental relationship. It's like when you start maximizing parenting from the beginning, you're really pulling the politics, the parent-parent politics out of the picture. When you start from an SPO, one, the child has far less exposure to one parent than the other. The non-custodial parent has far less exposure to their own child than the other parent. And just as human beings, that invokes a incentive to equalize things.
Sure.
Okay. Whether it's a child, whether it's some other thing that we believe as a human being we're being treated unjustly, that invokes in its evolutionary genetic aspect we all have. It invokes the will, the desire to equalize things, to make things fair. And we know that minus issues of children being involved historically. Now, when you bring the issue of a child being involved, your offspring, your genetic connection, that which you contribute half of the genetic makeup, it's similar to the evolutionary drive we have as if we weren't humans, but you walk into a bear's den or a tiger's lair or any other species in the animal kingdom, you start messing with their children, their offspring, it will bring up a defensive, aggressive posture. It's part of protecting your offspring. It's part of protecting your propagation of your family line. And the third layer is that these two drives already, when you have an unequal parenting situation, create conflict. If shared parenting can become a reality, what happens is the child's exposure as well as the parent's exposure to their offspring and to their parents becomes diffused. It diffuses that drive to enter into an adversarial relationship to equalize things. And both parents feel and believe that they have, and they become more secure, that they have a relationship with their child. and the child begins to build a security that they have a relationship with his or her parents.
Absolutely.
And
That,
and the other, I was just going to mention one other thing. So going back to the issues of politics between the parents, when you start out with a rebuttable presumption, you're surpassing, eliminating the parental politics. Okay. Now you're not involving whether or not mom or dad like each other, and based upon getting along or not getting along, that, you know, mom or dad are going to let the child have more time with the other parent. You know, that's eliminated out of the picture. And what happens is that the child getting put into the mixture of this politicking situation, actually the child is more insulated from this politicking situation, because the child knows and the parents knows that regardless of whatever their emotional politicking status is, they're going to get as much time with the child, and the child as much time with each of them.
absolutely.
Okay.
You know, and
So, I'm sorry.
go ahead. It absolutely. You know,
Yeah.
and I think that's what people need to realize, is that you're still both parents in a normal situation, right? When you have healthy parents.
Mhm.
That,
And then
you
the
know,
other
the
thing it
divorce,
helps
what
the
have you,
parents.
those issues go out, but you're still both parents. And if you're focusing that both parents are going to be involved in the child's life, I think 50-50 should be done. But
Mhm.
usually there's a lot of discourse that are still around. There's a lot of feelings that are not there. And what is giving now, what, in my opinion, and what I've learned of today, is that by the knowledge, or the less knowledge of, the separation and the discourse is added into flames, because they remove the child from the other parent, like in most cases now. And what happens is that the alienation starts, and one is seeing it. Maybe the other one is seeing it as well and taking advantage of the whole situation.
Mhm.
Especially if that one parent has discourse against the other, and they're
Mhm.
going to take that into that type of a atmosphere. So
Yeah.
it's going to be more of a vindictive type of usage
Mhm.
under the color of law than to help the child.
Right. I think the other thing that maximizing parenting does, it also insulates the parent, and allows the parents to have to deal with their own grief. I mean, most of this starts when cohabitating parents are separating, or when married parents are divorcing.
Sure.
And you know, separation is a great time of stress. And sometimes people do and think things they wouldn't otherwise do and think under great times of stress. But unfortunately, the litigation system gets involved in exactly that moment. And unfortunately, does more frequently to help create the situation of increasing adversarial relationship rather than decreasing the adversarial relationship.
Absolutely.
So that what I mean to say is that with shared parenting rebuttable presumption, what essentially you're eliminating the issue of politics early on. The message is the child's going to be with both of the parents as much as time equally as possible. I'm really sorry that you have all these feelings of resentment and anger and you know, these things that you're going through that are part of separation. These things occur, and instead of you being able to, or one parent or another being able to intertwine the child in all of that, it really gives more of a message to the parent. You're going to have to deal with this separation, these emotions, these things going on about your ex with yourself. And we're not letting the child become used as a tool, or preventing the child possibly becoming used as a tool. And so that insulates the child, and it puts the ownership of each of the parents to manage the separation divorce process. I think another thing you touched upon is that, you know, the belief that elimination of one parent over the other is in the best interest of the child. No, that's not in the best interest of the child. It's actually damaging the child. It's
Absolutely.
easy for the judiciary. You know, I think the most common example is like if there's parental conflict then you have to pull one of the parents away in order to decrease the parental conflict. No, that's not the intervention. What the intervention should be is maximizing the time as soon as possible, because then what happens, the child is less likely to have to deal with the loss of the parent. And I think that's what the judiciary forgets, and those associated with the judiciary forget. You're pulling a parent away, but now what you're creating is abandonment for the child and abandonment trauma, and they don't understand that fully. And what happens is now you're reinforcing the conflictual nature of the custodial parent, because many times the scenario is you get a high conflict custodial parent, and that over time, it just keeps provoking the situation, and the non-custodial parent is just unfortunately attempting to defend and stand their ground and protect as much time as they can with the child. And regardless of the scenario, what the judiciary may easily do is they have this belief that pulling away the non-custodial parent even more is helpful. It's not. It's damaging. And what is most helpful is maximizing the time. Because now what's happening, you're eliminating the politics, the conflict nature of the parents. The child gets as much time with both parents. So, you know, that's a misnomer. I think whenever there's conflict, of course, the litigation system is going to benefit, you know. Without the litigation system, you look at those associated in this whole system, they're benefiting financially at the cost of the parents, at the cost of the children. And this has been well publicized. This is not something that is a secret or new. And you even had people advocating that, you know, if there's any association with the lobbying groups, not to choose those type of attorneys to be involved in the case. But we know from other states, to go on a little bit more, I apologize for being a little long-winded, but we know from other states, most commonly Arizona, because there's follow-up studies coming out of Arizona, mainly from Dr. Fabricius. And there will be studies coming out of Alaska and studies coming out of Kentucky soon, that litigation rates decrease. Even before Arizona switched to maximized parenting, there was valid peer-reviewed scientific studies showing that on multiple measures that kids were measured on, they did much better when they had maximized times. And they also validated that kids wanted maximized times with both parents, but this was kind of after the fact, where they look back at their life as kids and, you know, growing up in divorce situations, that they wish they had that. But how else are you supposed to gather that data? You know, you can only gather that data by asking those that were involved, and to the best following the scientific method to keep it going.
Now, you know, and this is what I'm going to go back to.
Mm-hmm.
I'm going to go back to that. My belief, or what I gather from our conversation, is that most judges, they don't know that this is going on, or they don't know anything. They know something's going on. What I'm trying to say is they don't know much about the effects of parent alienation and the roots of it for them to actually be educated enough to make a decision. And if they don't have that, then I think the goal of all the different groups is to somehow pass legislation that classes for parent alienation is mandatory, especially for all those that are going in as a magisterial position, or associate judges and so on and so forth.
Oh, I agree with that. I think that if there's any personnel involved that's going to have an impact on the development of kids, it should be required that there's a minimum education on an annual basis for all organizations.
Absolutely. Doc, I want to thank you for teaching us a little bit more about what parent alienation is, and hopefully for those that have been affected with it, learn something to try to end it, try to change it as fast as possible.
Mm-hmm. Mm-hmm. I hope
Any
so.
other words? I hope so.
I mean, I think the current strides to bring Texas to a shared parenting situation is a very, very valid stride to make, and I hope it gets passed. It's what our kids need.
you know, and our kid, you know, because divorces are going to continue. This issue is always going to be there. So we need to take care of it now for the future generations.
Mm-hmm. If I could throw out an analogy, actually, I didn't devise this analogy. It was Dr. Linda Nielsen at Wake Forest, who I had the pleasure of communicating with a couple of years ago. And she had she had published a review study of 60 studies, and it was a very important study. One thing that, not just in that review, but has been contended even in other reviews, is the issue of conflict, parental conflict. You know, it's always an issue that comes about in any court hearing, whether parents can quote co-parent or not co-parent. And that will be the basis or the belief of whether there can be, you know, maximized parenting or 50-50 parenting. That's a total misnomer. I don't know of any studies that are published that have been able to measure how much parental conflict are in married or cohabitating situations versus not divorced and non-cohabitating situations. So you can't say that when parents, you know, if you can't have that comparison, then how do you know what level of conflict is too much that interferes with co-parenting or interferes with the ability to maximize parenting for the child? Again, one of the other things that she states is that, or she stated, was that maximized parenting and shared parenting is like a vaccine. You know, if you look at polio vaccine was developed. Polio was a devastating illness for children and adults. It hit children unexpectedly who otherwise were previously healthy functioning. Some of the kids died. They were fatalities. Some of them, most of them didn't die, but had tremendous disabilities. With those that had disabilities, there was all kinds of interventions, medical interventions to try to help them out. Some succeeded more than others. There's always a spectrum of rehabilitation that was able to be achieved. Until the polio vaccine, which mitigated the incidence or the illness happening in people, in children, and prevented it. And shared parenting is like that vaccine. Divorce hits kids, or non-cohabitation hits kids suddenly. It's unexpected. Depending on the parent-parent dynamic, you know, many kids suffer emotionally, psychologically. They go through therapies, they see psychologists, they see, you know, therapists, they see psychiatrists. Some kids, there's actually fatalities, suicide fatalities. If the parent-child dynamic is severe enough, some kids die. And with shared parenting, this is a mitigating vaccine. And one of the things she brought up, to her credit, is that why would you consider a vaccine only effective in one state and not another? You know, a vaccine is a vaccine. Look at our current COVID situation. When we say the COVID vaccine is only effective in Arizona or Massachusetts or, you know, some other state, not Texas, obviously not. So I think there's a good trend that's occurring and an awareness that's occurring that may not be favored by everybody involved in the system. But if, again, we just put it in the context of the kids, this is going to lead to the best outcome of kids and parents.
Absolutely. That's what it's all about, the best outcome of a child. And that's something that we have to bring forth.
Yeah.
And let's see what we can do, because I think I have a good feeling that the stride that everything's going, I think there's going to be some changes coming soon.
I hope so. I think so as well. It's been a pleasure. Thank you so much.
Thank you so much, Doc, and we will talk soon.
Okay.
And you be safe.
You too.
Folks, you all take care out there.
All right.
Peace.
I know.
Today in America, more than 5.5 million men, women, and children train in a martial art regularly. Buitron Academy has been serving Laredo for over 30 years now. Our adult classes are geared for producing the best in you, teaching you street-ready techniques. With the arts of Savate and Kinpo, you'll learn the traditions of these sciences of combat, as passed down professor to student.
Hello, my name is Stephen Plain, and to whom this may concern. Professor Paul Buitrón is an outstanding human being and a close friend of mine, where his martial art prowess and skill is at equal to his humanity. His teaching capabilities are what one would expect of someone from his caliber. I've been in martial arts since I was 9. I'm 65 years old now. However, if I had a son or daughter who needed to learn self-defense, anti-bullying techniques, and/or gain a higher level of skill in fighting, and in which I could not instruct, then Professor Paul Buitrón would be my choice. His martial understanding of his savate is higher than anyone else I have met. His pedigree is impeccable. He comes highly recommended by myself. Guru Stephen Plank. Thank you very much.
Hello, I'm Richard Planis. I was the vice president of the IKKA for Ed Parker for many years, 10 years before he died. And I still travel the world teaching all over. And I met lots of people through the years. One of them I want to congratulate is Paul Buitrón down in Laredo, Texas. He's opening a new school, and that's always good to hear. I've known Paul since he was about 18 years old. I couldn't even tell you how old he is now. We've known each other for a long time, and he's like a lot of people should be, takes art seriously. He incorporated many arts, in his school. He does, capoeira, silat, jiu-jitsu, eskrima, kenpo, lots of different things. Any art like myself that you see a value in, you can bring it in and incorporate it if you want to. Anyway, so he's opening a new school, and I'd like to recommend it to anybody who wants to train down in the Laredo area. Meet him, go see him, you'll have fun. Thank you. Bye.
Come train at the best kept secret of Laredo. Give us a call for your free evaluation at 956-401-4868 or check out our website at savate.biz. Follow us on YouTube and Facebook.